Mr. Tittle's reputation in the community is his company does great work. He's a horrible person that you would never want to date your female friends or female relatives under any circumstances.
The defendant's motion in order to show cause. Present is Attorney Anthony Bologna, representing the defendant, Petitioner Gregory Tittle Sr. Scott Longton is present, representing the plaintiff Carrie Tittle. The parties have conferred this morning with Ms. LaPrada from the front of the court. Ms. LaPrada has provided the following recommendation that there should be no social media posts regarding the other party. Of course, that was previously ordered in the judgment of divorce, was it not?
Correct, Your Honor.
What was previously ordered?
I would say, Your Honor, in some fashion, yes and no. It was non-disparaging type of typical language. It would be the language that I would typically see as it relates when there's kids in a divorce, not necessarily what's going on under these circumstances, Your Honor.
Court would agree. It's simply the judgment of divorce language, something credited disparaging remarks on social media. I guess this recommendation, this language would expand that to be no social media posts for any other party at all, whether it's favorable or unfavorable, disparaging or not. These two parties need to move on with life. All right, to Mr. Bologna, will this recommendation, if not by the court, will this address your client's concern this morning?
It does, Your Honor. My client just wants it to stop and doesn't want this to ever happen again. And he wants to move on, and he has moved on. So this definitely will address our concerns, Your Honor.
Mr. Longton, obviously, your client does likewise agree with this recommendation?
She does not agree, Your Honor. And Your Honor, if I'd go into argument on the issue.
Well, these parties have no children in common, correct?
Correct, Your Honor.
They do have children in common, just not minor children.
Yes, not minor children.
I'll say, all right. Again, they can post things regarding the children, it's not the other party. All right, Mr. Longton.
Your Honor, the issue is that although there's the judgment calls for no defamatory type of language, this is a case where defamatory language would be based upon what would be either one, truth, or two, Mr. Tittle's reputation in the community. And you cannot defame somebody in the community who already has a reputation for being an abuser. What we found through continued discovery is that most recently, Mr. Tittle was at the Greektown Casino with his current girlfriend. I'm waiting for the videos of the security footage, but Mr. Tittle punched his current girlfriend in the face while in the elevator. This is the same type of abuse that my client went through throughout the years of marriage. What she's now done is she's become a victim's advocate. She's creating a company for domestic violence survivors, and that's what she's posting about is her personal experiences as a survivor. And Mr. Tittle is not named by name. He is not named by company. It was just my client stating that this is what she went through in her years of marriage. She does not carry the same name as Tittle. So the only people that would have, quote unquote, brought this to Mr. Tittle's attention are the people that know him and her together. And by reputation in the community, people know Mr. Tittle in the community as an abuser and a violent person. His criminal history speaks for itself. The social media posts about Mr. Tittle outside of my client, where he's beat his girlfriend up in Florida and left her, left his current girlfriend in Mexico. It continues on. And this is the reputation that Mr. Tittle has in the community. This is what he's created for himself. So for my client to disparage Mr. Tittle, one, it would have to be either false, or two, Mr. Tittle would have to have a different reputation. You can't disparage somebody who already has that reputation. We also have the First Amendment freedom of speech issue here, where Ms. Tittle has the right to make these statements of her own upbringing in her marriage. And with that said, I believe that the non-disparaging language in the judgment, when there's no children, one would be against public policy under a case like this. Two, it would be in violation of her First Amendment freedom of speech. Three, that is Mr. Tittle's reputation. I have a litany of witnesses that I can call. Mr. Tittle's reputation in the community is his company does great work. He's a horrible person that you would never want to date your female friends or female relatives under any circumstances.
Right, and Mr. Longton, you're not going to sell the court on that. First of all, this is not a civil defamation action where truth is the defense. This is a disparaging remarks issue. And obviously there was consent judgment. Ms. Tittle agreed to this language in the consent judgment. She's not the watchdog for her ex-husband. So if she wants to advocate for domestic violence victims, that's fine, but she should not reference her husband by name or former husband, because they're married 26 years. People know who the ex-husband is. So the court's going to adopt Ms. Pratt's recommendation. Neither party shall post anything regarding the other party on social media, whether it's true or false, or favorable or unfavorable. Just move on with life. Anything further this morning?
No, Your Honor, I understand, and thank you for the time and attention, Your Honor.
Now conclude this matter. Hopefully these parties can move on with life and they're not going to be back before it's court on such things. Come on, they're adults and let's move on.
Mrs. Maui expected me to commit, and when I didn't, she went on a slander campaign. 20 days. It will be 1 year exactly since this started. I've gotten to see my son 1 hour a week since July. He was illegally taken from me for 6 months over false accusations of a woman who was about to be exposed at work.